SJC-12424, Commonwealth versus Rivera.
Good morning, Ms. Keddick.
Good morning. May it please the court, Chief Justice Gantz. This is primarily a 33E argument, and it concerns the findings of premeditation and extreme atrocity and cruelty, where each of those elements were really not proved without problems. The premeditation, although technically under the law in this state where premeditation can occur within seconds, in fact, this case showed that it was a spur-of-the-moment act by the defendant when his partner of almost 22 years began to pack to leave him for.
Were there some statements he made about wanting to do him harm before the
Well,
proceedings?
that's one of the issues that is raised in this 33E argument. For the first time at trial, one of the witnesses had stated that the defendant said at the time he was committing the crime, "I told you I was going to kill you." She had never said that before. She was impeached with the grand jury transcript, with the fact that she hadn't said it.
But I guess our framework has to be the light most favorable, though, right, on this issue?
Well,
Well, actually, maybe not on the 33E.
well, that's just it. I mean, certainly it's not a reasonable doubt argument. Certainly it's not saying that either one of these issues would be prejudicial. But because the witness was not impeached with the fact that she did not say this even during her police questioning that went on for a while, that was
She was impeached with that, right?
She was not. She was, because the trial attorney didn't impeach her with it. It's only part of the record because I had raised a 33E in the trial court and admitted the transcript. So what she had said is, she said, "Yes, I did tell that." The defense attorney said, "Well, you didn't tell that to the police." "Well, I did. Yes, I did tell it to the police when they interviewed me." So the jury didn't hear that, in fact, she had not. And there were 3 different times during that interview where she was asked about those specific events of when he entered the room and began to stab the victim. She never said that he mentioned that statement. And so.
But didn't Bianca testify in the grand jury that her mother said that the defendant had said, "I told you I was going to kill you," or something to that effect?
No, well, what Bianca said is that her mother told her that what the defendant said is, "I told you I was going to do it."
And that was said in the grand jury.
Right, but only by Bianca, not even by Valentin, who.
Right, but am I correct, or is your brother correct, in his brief, as I understand it, that Bianca said, "I don't speak Spanish. I heard him say something," and that her mother said that what she had heard the defendant say was basically, "I told you I was going to do it," or
Right.
And somehow the effing word got in there, but I guess it varies between the grand jury and Bianca's testimony. Is that all correct?
Right.
So why is that not fair warning that and also corroboration that the mother had heard it if Bianca heard her mother say it?
Well, what we have is a much more prejudicial statement. "I told you I was going to kill you." That was never said before, and that's much more highly incriminating. And the problem is the jury wasn't.
But I don't get it. I'm reading from your brother's brief, and but at defense counsel's request, she, meaning Valentin, reviewed her grand jury testimony and acknowledged that she had not, in fact, told the grand jurors about the kill you statement. Defense counsel also elicited testimony from Detective Samar that Valentine did not tell him about the kill you statement. So the impeachment was done here, right?
Well, there were,
That's Valentine.
before the jury, the impeachment was not completed before the jury, so the jury was not told.
I just read you, is that inaccurate? Script 2, pages 91 to 92, and transcript 2, 141 to 142.
Oh, I don't have the you're talking about the
But I'm reading from pages 20 and 21.
Oh.
It looks like she was, in the Commonwealth's brief, it looks like she was impeached.
It's,
Mr. Steinfeld's nothing but persnickety. He tends to get those.
okay, so Bianca was impeached. Are you talking about footnote 10?
I'm reading
Oh.
from pages 20 and 21 of the
Okay.
Commonwealth's brief.
Oh, 2021.
And at defense counsel, I mean, you can look at
Here,
it.
Right.
I've got it in front of me. The questioning is, this is on 92, transcript 2. And nowhere in that testimony on those pages did you tell Mr. Camilio that Miguel said, I quote, "I told you I was going to kill you," did you? I guess not at the grand jury, but I know I did. I guess not at the grand jury. I was shocked. But when I asked you the question of whether or not you told the grand jury, you said, "Yes, I did," didn't you? "Yeah, I believe I did. I don't know," but you didn't. Is that fair to say? Yeah.
Right, so she was impeached by her grand jury testimony, but was not impeached by the fact that she didn't tell the police. And in fact, she had,
Defense counsel listed testimony from Detective Samard that Valentin did not tell him about the kill you statement.
Right.
Transcript 2, 141 to 142.
right, he was the first police officer on the scene, and she did not tell him that. What she said she told was Detective Burke, and the defense attorney did not then impeach her with the fact that she did not tell Detective Burke and Labarge during a prolonged questioning that was not right at the scene of the crime.
To take a longer view at this, rather, your argument under 33E is it was spur of the moment, we should reduce it because there was inadequate evidence of premeditation.
Right.
What makes it, in your view, a spur of the moment stabbing?
Well, because they had been, certainly there was a information that the defendant had that the victim was thinking about leaving him, and he had asked Bianca and Valentin to please try to talk him out of it. So we know he still held out hope. Even the judge had said when he wanted to give a voluntary manslaughter instruction, well, you know, hope springs eternal. He still wanted to. The evidence was that they were still sleeping in the same bed the night before. And right before the crime, there was an argument going on that Bianca had taped, and the Commonwealth had quoted in its brief, and they had an argument, and the victim had brought up something that the defendant had done wrong through their relationship, and he said, "You're right, I'm sorry." This was right beforehand. It wasn't, so it was this breakup, a heartbreaking breakup, and then as soon as he began to pack to go, the defendant, that's when it became, you know, violent, and yes.
Well, but he leaves the bedroom, right?
Yes.
He goes into the other room, grabs a large knife, and the two women who are present don't see the knife, right? When he walks back in.
Right. So
Suggesting some kind of concealment of the knife. That's not enough for premeditation?
Well, because this is a 33E argument, sure, I'm not saying that he wasn't proved guilty beyond a reasonable doubt. I'm saying that under 33E, the law says that even though technically someone may be guilty, there's evidence in this particular case where it's more consonant with justice that it be second degree.
How about the fact that we also have extreme atrocity, right? So we have 13 stab wounds, including sort of, in the eye, right? Is that right? I read a lot of murders this week.
Yes,
He
yes,
stabs him in
there
the
was.
eye.
Yeah, right. And for a life without parole sentence, there really has to be, the aggravating factor, premeditation, extreme atrocity, and cruelty. And it has to be, of course, more than the atrocity and cruelty of any murder. And yes, this was, atrocious and cruel. But we're talking about, extreme. And so the fact that someone is stabbed to death can't.
How many of those stab wounds were independently fatal?
My understanding is that the only one that was possibly fatal was the one that pierced his aorta and his lung, because what the ME said was it was the blood from the aorta that collapsed his lungs with the filling up of the blood. There were 4 other stab wounds, that were deeper than they were wide. But there was nothing in her testimony that said that they were. But that's not I guess the point is that, yes, stabbing is, atrocious and cruel, but it's not a rare, unusual type of death, and there are statistics in there about how it's not rare. Even the number of stab wounds, because one of the factors in the Kunin case is, whether there was more that was necessary to commit the crime, to cause death, and so for the average number of stabbings, there's 4 or more stab wounds. In this case, there were 5. So, even in the extreme atrocity and cruelty, the stabbing isn't out of the universe of the atrocious and cruel of any stabbing. So it's not as if there was this was a relationship that had been a violent relationship, that there was domestic abuse. And what the evidence was from the witnesses, the sister-in-law and the niece, is that Mr. Rivera was fairly pathetic about the whole thing, about the breakup, pleading with them to talk the victim out of leaving him. And we do know that he had mental health issues. There wasn't a mental health defense, but he did have mental health issues. He was disabled. Because of that, he was taking anxiety medications and such. So it's just not the type of long-term, violent, horrible crime that finally this is what it came.
In your brief, do you have cases specifically that you can compare where we've reduced the verdict?
No, because of this particular.
Or you say that this is a good case for 33E review,
Right.
and you've given us some problems with the evidence,
Right.
and explained the nature of the relationship. Are you familiar with any of our cases that have done just that have reduced this kind of case to second degree for the reasons you're suggesting?
Right. Well, there in a case. I'm not going to remember the name of it. It was actually the quote was in the Commonwealth's brief, where this court had, it was just a 2017 case, where this court had listed what factors this court looks at when determining whether it would reduce a case using 33E. And one talks about the nature of the relationship before, whether there hadn't been problems before, and this is a particular case. And in fact, the case that this court had decided on December 14th, I believe it was, where it lowered the crime from first degree to second degree, where the defendant had killed his roommate, and there had been no problems with the 2 roommates before there, and so it was just this inexplicable crime. Now, we have an explanation here, but I would say that the explanation is mitigating, not Not that, of course, there's any argument that being upset that your lover is leaving you or your spouse is anything in mitigation itself. It's just that all of the factors in this particular case, even the knife, he didn't bring it to the crime, and that is one of the factors that this court looks at. And the knife was just lying in the sink. He didn't even go and make an effort to try to find a knife. It was just lying in the sink. It had been used by the guests beforehand. So there is spur of the moment. And he does have mental health issues, and although certainly not as bad as in the Sheila Berry case where this court lowered from first to second because of mental illness. But the jury had rejected her defense, and still this court lowered it. So although there isn't a case that's sort of like an acetate overlay that has the same facts, there are many factors in this case that this court has used in other cases to lower from first to second degree.
I guess the issue is what distinguishes this case from so many of the jealous lover cases that we get. You don't have anything that would suggest voluntary manslaughter. You don't have reasonable provocation. You don't have sudden revelation of infidelity. You don't have sudden combat. So you're not in that world. Why would this not essentially say that all these, and the nature of the stabbing is actually consistent with it being a crime of passion, a crime of anger? What would, if we do what you want, does that not suggest that we're putting these into second degree world where we have not before?
No, because I think that there are two things different here. There are times, perhaps too often, when someone kills their partner or spouse when they're leaving. There had been a history of abuse in it. And also, there's certainly a number of cases where it's planned, where they plan to go and kill the person, the victim. This case, there wasn't that. But also included in this 33E argument isn't just that this was a spur of the moment. It's that the impeaching evidence against Valentin, there were cases that this court found, I cited them in the brief, where the court found that when someone had not been properly impeached with a statement that went to the mental state of the person at the time of the crime, this court found there was, substantial risk of a miscarriage of justice. There would have been, they lost because of ineffective assistance to counsel, a defense. And in the case that was similar to this, the facts where the witness testified at trial that it was a joint venture case, and so the defendant was not the shooter. It was, so his mental state, did he have the same mental state as the shooter, was at issue. And the witness testified at trial that the defendant said before the shooting, "Die, motherfucker," but he hadn't told the police that. And the trial attorney failed to impeach him with the fact that he never said that to the police, although that would be highly relevant. And this court found that that would have gone far to allow the jury to determine his mental state. It didn't reverse in that case because there was other information that witnesses said, including that the defendant stomped on the victim's head after he was
But
shot.
what do you do? I mean, I did note that after the report that I read, the attorney said, when you told the jurors here that you told the officer during your interview that you told them that, you didn't really do that either, did you? And she said, yes, I did. And then Mr. Morris, I gather, is defense counsel?
Yes.
He said, one moment, Judge, could I just have 1 minute? And the judge says yes, and then he carries on, probably because he wasn't so sure that
Find it or,
that
yeah.
he could find that she had not said it. But the problem with all of that is that you do have Bianca heard it. So you do have a prior consistent statement that Bianca heard it being said, regardless of whether Ms. Valentin told the police she told her daughter.
Right, well, the argument is that it's not, it's saying, I told you I was going to do it is not quite the same as, I told you I was going to kill you. Also, there was other problems with Bianca's statement, because she had said that the defendant had said that sometime afterwards, but then said at trial that he said it on his way in, or, so there was inconsistencies in around that statement everywhere.
All right, thank you.
Thank you.
Mr. Steinfeld?
Thank you. Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth. I'd like to start just by clearing up the issue that came up, especially during some questioning from Justice Kafker about defense counsel's failure to impeach Ms. Valentin. And he, in fact, did, in one instance, fail to impeach her. He impeached her by failing to mention the statement. Valentin testified that she had told the grand jury about the statement and that she had told a detective from Lawrence named Burke, that she had told both of them. He said, I told you that I was going to kill you. During cross, she was definitely impeached with her grand jury testimony, where she did not say it. And she said, oh, yes, I guess I didn't say it. Then she was asked, did you tell Detective Samard? And she said no, but she never had said that she told Detective Samard. Defense counsel did not then say to her, well, but you didn't tell Detective Burke either, did you? And so if you look at the very next sentence on page 21, you read two sentences. The last full sentence of the first paragraph on page 21 says, although there was no such evidence at trial, Valentin did not mention the statement during her recorded interview with Detective Burke and Mass State Police Sergeant Bob Labarge the night of the murder. So there was a failure to impeach, but it was minimal for the reasons that I set out. It was a prior omission. And I think that the confusion there comes from the fact that she said, no, I didn't tell Detective Samard, when she never had said that she had. So I hope that clears it up. I don't know, maybe I've just made it less comprehensible.
I guess, did the jury understood that Valentin said that she said this at the grand jury, and she actually didn't, right?
Jury knew that she said she told the grand jury, but actually had not.
Right. The
So
jury
they
understood
definitely knew
one.
that,
The
and she
Samard-
acknowledged.
The Samard thing is more.
That's sort of not at all relevant.
Right.
The jury did not know that during her interview with Detective Burke that night of the murder, she had failed to mention the statement. That the jury did not know. But I say that she was already impeached with it, plus we have the prior consistent statement from Bianca. And this court has never held that the failure to impeach by a prior omission is enough for there to be 33E relief, especially when that witness has already been impeached by the exact same method in far more solemn circumstances under oath in front of the grand jury.
Did Burke testify?
No, but Detective Samar did, and perhaps that's why she was asked, well, did you tell Detective Samar? And she said no. So Burke did not testify. But
So there was no chance to confirm with Burke that she had not said that to him?
yes, that's correct. But I think he could have called Detective Burke. He could have shown by competent evidence. My sister put in a copy of the interview with Ms. Valentin in her motion for relief under Rule 25. So that's part of the record before this court. There's a transcript of that interview that she gave with Detective Burke where she does not say that the defendant said it. Also, Justice Kafker, there was no stab in the eye in this case. I also have read many murder cases this week, but I think there was a stab above the eye, but not in the eye.
Yeah, okay, so
And
what is so we have the death blow is to the neck area, right?
no, the death blow was to the right chest. There were no neck injuries.
But there's a stabbing right above the eye,
Right.
right? Okay.
Right,
That's-
and there was no evidence that that was a serious wound. I think it's fair to say from the ME's testimony that the fatal wound, that there was one single fatal wound, which was about 7 inches, on the right side of his chest that went through skin and soft tissue, the bone,
And what is
one
the
lung, the carotid.
Above the head is what? What is the stabbing above the head? Describe the detail on that.
I think that it was an incised wound, that is, that it was wider than it was deep.
Okay.
I'm not certain of that, but there's definitely no evidence I mean, there was a stabbing in the head. I just don't think that it was a very serious wound, and certainly there's no evidence that said that that wound contributed in any way to his death. We're pretty sure that the one wound, the stab that cut the aorta that caused the victim to start to bleed into his chest cavity.
I'm just focused on sort of the extreme atrocity
Yes.
issue. So we've got, and again, I remember there was a stabbing in the head, but I wasn't sure what it was. And
How many stab wounds in all?
There were 13,
And when
and 8 were incised and 5 were stabs.
any indication when the fatal blow was struck?
No, we don't know. Valentin testified that she first saw the defendant stab the victim in the back. That was not the case. There were no stab wounds in the back. And then she said he turned him over and just started stabbing him. She didn't say where. So we don't know the order of the blows. We don't know whether that was first or 13th.
All located above the waist?
Yes. Yes, there were 6 on the chest, 1 in the head, and 6 on the upper extremities. 3 on his right hand, which are apparently defensive wounds, 2 on his arm, and 1 on his forearm. So you have 6 wounds in the arms, 6 in the chest. 1 of them was very deep that killed him, plus 1 in the head for 13. None below the chest. But all apparently stabbing from his front while the victim was on his ground, or at least facing the defendant.
How big a knife was this?
It was I have the dimensions in the brief. I think it was a 12-inch knife with a 7-inch blade and a 5-inch handle, something like that. That's in the brief, but it was...
This is a kitchen knife?
Yes, it is. It is the biggest knife that they found in the kitchen, by the way. So the fact that it was in the sink, it's true, but there were photographs of all of the other knives in the kitchen, and this was the biggest one, and it's a fairly hefty, substantial knife. I can certainly have the clerk of the court.
I was just going to ask if it was an exhibit, and if we need it, we
Right,
can.
right. I assumed that, so I didn't have that done already. But I think that those are the dimensions of the knife. Now, as to...
So what, does your sister have a point that virtually every stabbing death done out of anger is going to fall into the realm of extreme atrocity or cruelty?
No, I think that it can be one, but here there's 13. And the number, the severity here there are no cases that hold that this number of wounds, including one that has this force and effect, has been not enough to satisfy the factors. And of course, it's up to this court's review under 33E to determine whether or not this should be second degree instead of first, but it has always held to be first, to be enough for... And I don't know of any case in which there are wounds like this in which this court has made it second degree rather than first, or manslaughter instead of first. I'm not aware of any, and there are several that I
But
cite
we've
that have
had
a similar
similar
number
to
of stab wounds.
manslaughter, but that's because there are mitigating factors.
Right, that are not present here. There's no alcohol, there's no intoxication. We all know who the sole aggressor was, the initial aggressor. And as to spontaneity, which I think is the defendant's biggest point, that this was the product of a spontaneous act rather than deliberate premeditation. I think I just, my article is not subtle, I just disagree with that characterization of the evidence. And I would point largely to the time that the defendant spent in the kitchen after he'd been arguing, and the victim took a bag, started packing some clothes, and said, "I'm going to my new boyfriend's house," or words to that effect. The defendant goes to the kitchen, and it's undisputed that he spends 90 seconds in there. And he makes no noise at all in that kitchen. And it's a tiny apartment, and the photograph showed, and the evidence showed, that if he had made any noise in that kitchen, then it would have been heard by the 2 women who were packing up at that point. But he waits for 90 seconds. It's not like he ran out, grabbed something, and ran back. And I still would argue that would still show deliberate premeditation, but the fact of 90 quiet seconds just shows that this was not at all spontaneous. And I don't think it's fair to say that it was a spur of the moment thing or that he did not bring a weapon to the fight. He certainly did bring a weapon. He went and got a weapon. And there are many, many cases that involve when people have an argument and someone goes and gets a weapon and then comes back to it, that's not second-degree murder, that's strong evidence of deliberate premeditation.
When did the 90 seconds begin and end?
Pardon me?
When did the 90 seconds begin and end? Was it after or before?
The
the knife
90
was-
seconds.
90 seconds.
The
Did he have the
defendant-
knife already?
Well, we don't know when he picked it up because he was alone.
Okay.
We know that when he walked into the kitchen, the big knife was sitting right in the sink by itself.
Okay.
And there were other knives in a butcher block, plus there were knives in a drawer. So the two women see him going into the kitchen, and they don't know what's going on. No one knows what's going on for that 90 seconds. All they know is that at the end of that 90 seconds, he comes out of the kitchen with that big knife, hiding it in his right hand as he passes the two women on his left. So he's obviously concealing it, or the jury could have inferred that. So it is 90 seconds in which he is in the kitchen by himself after he's seen Omar packing a bag to leave. This is just simply not spur of the moment. This is going to get a weapon, thinking about what am I going to do, and as soon as he gets back in, there's no more argument, there's no more discussion. He starts stabbing immediately as soon as he goes in, and he shuts the door. And he tells the officer, well, I shut the door because, the women were out there. So that's a clear implication that he knew that he was going to stab him with the knife that he had by his side, concealing it, that he didn't want them to see him stabbing Omar Mendez. I don't know of any case in which this court has held on similar evidence that it's either a manslaughter case or a second-degree case. I think this case has none of the traditional elements of where this court has done that. And in fact, is a fairly clear cut. Though, of course, tragic, as I say, it's the end of a relationship, but it's far more tragic for the victim, the innocent victim who's done what, who only wants to see someone else, which is not a crime. But for the defendant to plan and then to execute him with extreme atrocity or cruelty, this court should uphold that verdict of the jury. And of course, the fact that the key witness, or that a strong Commonwealth witness was impeached, this court said very recently in Moore, deemed it patently absurd to argue that because a key Commonwealth witness was not credible because he was a drug addict. Here, it's the exact same argument, that you shouldn't believe this witness because she was impeached with a prior omission, which is a far cry from anything that's ever been held sufficient for a verdict to be reduced from first to second degree.
The 90-second estimate comes from,
That comes from Bianca.
not from Ms. Valentin.
That's right. But in the defendant's statement of fact, she says that the fact is that he was in there for 90 seconds.
So he confirms that
And he
in his
says
statement.
in the statement that he got it from the kitchen, but he doesn't say how long he was there. But it's true, Valentin did not also say 90 seconds. It comes just from Bianca. But his statement implies that he was in the kitchen, that he went from the bedroom to the kitchen. But as I said, he doesn't say how long he was there. But it's still evidence that the jury could have credited. And there was certainly no, she had no reason to lie, and et cetera. There was no substantial impeachment of her testimony. She loved both of them. So I don't think there's any reason for the jury to have disbelieved that. But it's true that the only evidence of the 90 seconds was from Bianca. I don't have anything to add to my argument on the motion to suppress, and therefore, if the court has no further questions, I will rest on my brief.
All right, thank you.